Good afternoon, Your Honor.
Good afternoon.
I just wanted you to know that I love all my children. And this is the hardest thing that I've ever gone through in my life. I know that I made mistakes. I'm sorry. But I did try my very best. It makes me very happy to hear that Christopher is doing so well. And I heard that at trial. I only wish the best for my children. I've been working hard in therapy for over 2 years, and I've been 100% compliant with this court and with the DNN court. I've been sober for 23 years and have been an active member of Alcoholics Anonymous, including the past 3 years. I currently am in school for a paralegal degree, and I'm due to graduate in December if I'm able to finish. I'm currently a cake decorator at a bakery, and I have stable employment and stable housing. I would pray that you please let me have probation so I can continue to get the help and therapy that I need, continue in my AA program, and complete my education. Thank you for listening to me.
And that is all, Commissioner. Thank you very much.
All right. Mr. Dawson, do you want to respond?
No.
All right. Let me make a few statements that I think are appropriate, and then we'll talk about the sentence. I see things some differently than the PSI writer did. I think Ms. Abcug is manipulative. I think she, in this particular case, was so meant to be dangerous to the community, to her own son, to the Plotke family, potentially to others. I think in order to believe her version of the events, you have to disbelieve everybody else. And that's typically not the way things go. Somebody may have gotten it wrong, some doctor may have gotten it wrong, but in this case, she sees herself as a victim and continues to see herself as a victim. You are not the victim, your son is the victim. And I haven't heard a word other than you saying, I'm happy he's doing better. I haven't heard a word of accountability about the things that happened to him. I get that there's an appeal. I understand that in all of these cases, when there are convictions, that there are likely appeals, and there will be. So perhaps some of those statements are not appropriate while something is, while an appeal is being contemplated. But I started last night going through testimony, looking to see if I remembered things correctly. And just in a very short amount of time, I started to mark, and then I just quit. I started to mark the contradictions that were clearly apparent in Ms. Abcug's testimony. In order to believe that version of events, you have to disbelieve doctors, lawyers, her own children. You have to disbelieve her own children. I did not hear a single word about how painful it must have been, Ms. Abcug, for your own children to have to come and testify about the fear that you instilled in them, that your plan to go and by force retrieve Christopher illegally, that somebody might get hurt, might be their own brother, might be you in the aftermath, might be the Plotke family. I didn't hear a single word from you about the impact you had on your family by putting that plan into place. And I look at the pre-sentence investigation and I see the recommendation and I'm stunned, honestly stunned. I would not have gone there at all. I'm not sure I will at this point. But from what I saw at trial, from what I see in these reports, and what I see in the testimonies, totally different from what they saw as the pre-sentence investigation writers. I don't know if they were provided the photos that we saw during trial of the impact, the physical impact you had on your son. It was devastating to this court to see him in the condition he was in prior to being placed in foster care. It is a delight and a thrill for this court to know that he is thriving. But he is thriving despite what you did to him. And it is unimaginable. I understand the medical child abuse constraints and what that involves. I understand that often it's not an intentional hurting of somebody, but intentional or not, you hurt him and you hurt your other children watching it. I cannot imagine that none of that was addressed in your statement. None of it was addressed to the PSI writer. I don't think you're getting it still. I'm not sure I can do anything that will assist with that. As your attorney notes, one of the things that is really important to this court and has always been is to hear what people listen to their words and really try to hear who they are from their own words, if I can. Your testimony during the trial was without credibility completely. You were contradicted at every turn. And I can only make from that was because there were things you didn't want to talk about. You didn't want to acknowledge. You didn't want to remember. The doctors you blame made their evaluations and their treatment and diagnoses based on what you were telling them. And you had a really hard time saying that during the trial. In fact, I'm not sure you did say it. I'm not sure you said it even once. You did say on minor things, well, I told them that he had occasional seizures, but I never said it was regular or frequent, or I never said it was, I don't know, you were parsing words on it, I guess, is what I'm trying to say. I never heard what I wanted to hear, not then and not today. You've been getting treatment, you've been helping others. I hear that, and those are good things. But I still see, I think what Mr. Dawson appropriately pointed out, is you still see yourself as the victim here. You got on podcasts or websites or something and talked about the system being so broken that it was illegal, people getting millions of dollars to steal children from families. And especially interesting to you was that Christopher was disabled and they get extra money for taking him. Based on what? These individuals were trying to help your son, trying to protect your son from potentially death, because that's where you were headed with him. I have seen it. I've seen it recently in other cases, and I don't want to see it anymore. I don't know what to do, Ms. Abcug, to get through to you the things that you're not focusing on that are tremendously important in this case. The harm that you caused not just your son, but at least 2 of your other children. The harm that you caused the foster family who was only doing what they felt appropriate under the circumstances. They didn't know you. They didn't know you from Adam. They took your son in voluntarily, willingly, to care for him until you could get him back. And rather than going through the steps to lawfully make that happen, you went around the system, and here you are. I don't know what to do to get through to you. Are you helping some people? Yes, I suppose you are. But sometimes it's much, much easier to focus your attention on others rather than taking a good, deep, hard look at yourself. Pretty much easy to go and spend that time supporting and lifting up others. I would encourage you to spend 100% of your time digging deep into yourself, looking at you and why these things happened. And whether or not you can acknowledge at some point in time that you had some huge responsibility in this game. And I don't mean to call it a game flippantly. It was not a game. People were seriously injured. I will be haunted for some time, those pictures of your son and the disabilities he suffered at your hands, especially knowing that he's thriving now and that all of those were probably things that could have been avoided. I looked at some of the comments that really struck my my attention when I was going through the reports and the psych eval and the pre-sentence investigation, that, well, he didn't really need to be in the chair all the time. You acknowledge that sometimes you put him in the chair while shopping so he wouldn't reach out and grab things. Okay, well, I don't know what to make of that, frankly. All of those things are upsetting. And that's just one of dozens of things. If you read and look at those matters carefully, you learn much more about a person than you expect to if you read things and listen carefully. I can tell you what my thought was before we came in today. My thought was 3 years DOC, maybe suspend a year of that, conditioned upon maybe not having any issues at DOC. I am shocked by the recommendations, a little bit put off by the recommendations. I think there is a potential, as long as Ms. Abcug continues to see herself as victimized by the system and by everybody else, that she will be dangerous again. And I don't know what to make of that. So, anybody want to address the things that I've addressed today? Mr. Dawson, Mr. O'Hanian, either one. If you don't, I'll go ahead and get sentencing done. But if you want to address any of those things, I'm happy for you to.
No, no. Your Honor, only to state that I do understand the court's concerns. I do. And, you know, I know you are in a difficult position, but our request would still remain that the court follow the recommendations of the PSI, of the district attorney, and our request, and allow her to continue getting the appropriate and intensive therapy. She has no objection to any condition of probation the court does see fit. But we think that given the fact that this is her first felony conviction, and given the fact that most individuals who come in front of you who are sentenced on a Class 5 felony do receive probation, we are asking the court to sentence her to the probation. And she did serve 143 days in jail during COVID. And Your Honor, that's not an easy task. And that's not something that is simply, I know the court remembers it very well, but it was such a hard time. It was such a hard time for all of us. It was such a hard time to be in jail. And she suffered. She suffered greatly. And I'm not saying that she's a victim by any means on that. I'm just saying it was really tough, and it is a significant punishment. So we're asking the court to consider that. I know you are. Thank you.
Your Honor, if I may,
Yes.
do you mind
do not mind.
The only thing I would throw out, Judge, and I heard the court's position on this case, and I don't disagree. The only other thing I can suggest to the court is, although the court indicates that you're inclined to do 3 years DOC, which would be toward the maximum of what she could get.
I thought it was an extraordinary circumstance, and that was a 6-year term. Am I wrong?
I don't believe, because she does not have a prior criminal history, you could get to 6.
I thought the nature of the crime on child abuse heightened that to some extent,
Child abuse is an extraordinary risk crime, Judge.
but it's not the F5.
Correct.
Gotcha.
As the court is probably aware with the Department of Corrections, since this is not a crime of violence, if the court were to sentence her to 3 years DOC, she would be immediately eligible at 50% plus good time, which takes it down to roughly 33%. That does not include recommendations of transition to community corrections, which is still considered to be part of the Department of Corrections. And I can tell the court, I sit on the Community Corrections Board, and there's people who get 7-year sentences who come before the Community Corrections Board after 9 months.
I know.
So in some respects, if the court sentences her to a term of probation, the court will actually be ensuring some greater measure of community safety, because the court can fix a more specific length of supervision, and probation can, again, keep her on GPS and will be the one recommending if additional mental health services would be out there. This is one of those rare occasions, Judge, where my concern would be if the court does sentence her to DOC, she will be back in the community, not to be facetious, but before we get home.
I guess my thought with, or at least partially what I was thinking, was that comes with the trailing mandatory parole that is also supervision. And from the court's perspective, that's a benefit. So that was the court's thought. And I appreciate Mr. Dawson, the reminder that it's not a crime of violence, so it goes 50% and then down with good time. I just think this is a disturbing and much more disturbing case than the charges would indicate. And I'm sorry that it's that way. I don't like my options very good. On the count 1, I understand, or I believe, the punishment range is 1 to 3 Department of Corrections with the trailing mandatory parole period of 24 months. On count 1, the court will impose 3 years DOC, fully suspended. That is going to be conditioned upon her successful completion of a sentence in the medical child abuse count of of 24 months county jail with all but 60 days suspended. Now let me ask before I do this, am I creating an illegal sentence per almond by ordering it in that way?
Judge, it would be my belief, the only exception to jail sentence in excess of what can be done, I guess the short answer is yes, Judge.
Okay,
Unless the other crime is a crime of violence or a lifetime sex offense, I don't believe the Supreme Court has carved out any other exceptions where an extensive portion of jail can be imposed or DOC can be imposed, followed by a period of probation in a single case.
and that was my reading of Allman, but I really, gosh, I think that hamstrings what the court can do.
And just for the record, I do agree with Mr. Dawson.
Okay, then let's fashion it differently so that we can still reach the same goal. 3 years DOC on count 1. That will be fully, oh, I can't do it that way either. Does it violate Almond if I impose 3 years fully suspended except the 60 days jail that you're talking about?
Your Honor, so would the court's intention then be to sentence my client to probation, DOC suspended, and then jail as a condition of probation?
Yeah.
No.
That's what I'm trying to do.
My understanding is that would be a legal sentence.
Okay.
I think you can suspend whatever you want, right? I agree. Yeah.
Okay. All right, 3 years DOC, fully suspended except 60 days county jail as a condition. And the probation term?
That's fine. Your Honor, we would really defer to the court on that. Whatever length you see appropriate, we're fine with. Given the fact that this would be a sentence that is not a stipulated one, this court would always have the ability to reconsider that even throughout the pendency, even if the probation department were to recommend
Sure.
that says it's great in 2 years and you want to take another look at it or something like that. So we're fine with that.
Okay. 24 months supervised probation. Do we need to talk about additional terms that will satisfy the court that she is not going to be a danger and not going to decide that she needs to go retrieve Christopher by violent means?
Your Honor, I certainly do not think so. As my client has shown for the last 3 years, she is, I mean, I understand, and I'm not trying to minimize the foster family. They've been through a tremendous amount. We don't want to do anything else that may put them through any more stress or anything like that. But as I stated before, she was on GPS for a long period of time, no violations. The court determined that. But if the court wants to put conditions at the, if probation feels that they're appropriate, because once again, this is a court-given sentence. I think the court can really has a lot more latitude than you do on a lot of stipulated sentences that you can say, I'm going to give this to probation at discretion. We're totally fine if the court orders the psychological evaluation to go to probation that we filed in the case, order the conditions of the psychological evaluation because they are being met through the DNN case, for her to continue that treatment and all the recommendations that are in the PSI.
That evaluation is nearly a year old at this point.
Yeah.
So what I will impose is conditions, monitored substance abuse, including drugs or alcohol. So I am specifically ordering no marijuana use. I understand that there has been some for particular reasons, but I want to closely monitor any substance abuse, including marijuana.
Got it, Your Honor.
The psych evaluation that was provided in this case and in the DNN to probation, to be provided to probation, and within probation's discretion, if they want to require another evaluation and to follow any treatment recommendations they make.
Sounds good.
While on probation, no travel outside the state unless the court authorizes it. I want to keep a handle on that. So that'll be only with court authorization, not probation authorization. Comply with any orders of protection that are currently in place. Maintain employment, preferably full-time. If that drops below full-time, the court and/or probation should be notified with an explanation as to that.
Your Honor, totally understood and agreed upon. Would the court fashion it that it's either full-time school and work? She just got to finish up in December, so through December, it might be that she's just finishing up her school and not totally full-time, but as soon as she's done, she intends to, wants to, and will be working full-time.
Complete school.
Good, thank you, Your Honor.
Right, so, yes. And paying outstanding fees and fines, specifically to include the GPS monitoring fees, that we got the report on. Count 2 is the 24-month probation.
For count 1, it's 3 years suspended. And for count 2, is that where you want to do the 90 days of recognition? Good deal, thank you.
All right, anything else that we need to address today?
I think that's it.
She probably ought to go stop by probation today.
She will be on her way.
All right. Ms. Abcug, please give the things that I've noted some thought.
Thank you very much, Your Honor. I know this was difficult, but,
I'm good. I wish I'd had more options.
Judge, when do you want to have her again?
She needs to remand today.
Your Honor, our request was that 143 days of pre-sentence confinement time.
I'm not going to authorize the credit. This is a new 60 days without pre-sentence confinement credit.
Understood. Your Honor,
As a punitive sanction in the case, as opposed to simply just giving her credit and calling it good.
Your Honor, I understand the court's order. Our request would be for the court to consider allowing her just a little bit of time before turning herself in. As I stated, she has been 100% compliant on pre-trial. She has numerous medications that she is on right now. We just want to make sure that all the prescriptions go down. She's just started getting another kidney stone. She has kidney issues. So our request would be for a stay of execution.
To when?
Your Honor, if the court would be willing to do a week, that would be great.
Any objection to that, Mr. Dawson?
Judge, I would defer to the court. I guess I'm slightly torn in the sense that the pre-sentence investigation report recommended jail as a condition, so she should have been prepared to go today. That said, with the court suspending 3 years DOC over her, if she fails to appear in a week, the court would have grounds to immediately revoke the sentence. So I will defer to the court.
Okay. Yeah, okay. The court will order remand November 10 by 3 p.m.
Got it. So, in other words, she is to report down to the front of the jail at 3 p.m. To be remanded.
Yes.
And I'll remind her, as the court always does, get there a little early because it takes a little while to process.
It does.
Will do.
Thank you.